Imagine England in the early 19th century. Horse-drawn carriages, top hats, and high-necked dresses. Now, consider a world where a gentleman's word was his bond, and contracts were often sealed with a handshake rather than a signature. This was the setting for the landmark case of Routledge v. Grant. Rewind to 1828. Mr. Grant, a man of means, was interested in purchasing a house owned by Mr. Routledge. Grant offered £1,200 for the property, and, in a gentlemanly fashion, allowed Routledge 6 weeks to mull over the proposition. This was a world before email or instant messaging, after all. Time was a luxury, and decisions were not to be rushed. However, Mr. Grant, perhaps feeling the pressure of the ticking clock, withdrew his offer after 3 weeks, before the end of the allotted 6-week period. Routledge, once informed of this, immediately attempted to accept the original offer, but alas, Grant refused. The stage was set, and thus the case of Routledge v. Grant was brought before the court. Fast forward to the courtroom, where the question under consideration was whether the offer could be withdrawn before the expiration of the 6 weeks. The court, deliberating on the matter, ruled in favor of Grant. The verdict: an offer can indeed be withdrawn at any time before it is accepted, even if the offerer has promised to keep it open for a specific period. This decision was based on the principle that an offer is merely a statement of willingness to enter into a negotiation, rather than a legally binding contract in and of itself. It was a defining moment in contract law, setting a precedent that continues to shape legal understanding to this day. Key points to remember from Routledge v. Grant. Firstly, an offer can be withdrawn at any time before acceptance, regardless of any stated time frame. Secondly, the promise to keep an offer open is not legally binding unless supported by some form of consideration. And thirdly, acceptance of an offer must be communicated to the offeror. Now, you might wonder, why is this case significant? Well, it underpins the flexibility and fluidity of contract law. It highlights the importance of clear communication in contractual agreements and acts as a reminder that until a contract is formed, parties are generally free to change their minds. In essence, Routledge v. Grant serves as a cornerstone of contract law, a testament to the ever-evolving dance of offer and acceptance, a dance that continues to be choreographed by cases just like this one, even nearly 2 centuries later. From the cobblestone streets of 19th-century England to the high-tech courtrooms of today, the legacy of Routledge v. Grant lives on, influencing and guiding the decisions of lawyers, judges, and law students around the world. That's all for today. Thank you for joining this journey through legal history.